Hi, and welcome back to I Now Pronounce You Divorce, Malone Hatley's podcast. I am your host, Dan Cuneo, and joined with me today is William Koontz out of our Columbia, South Carolina office. Hi, William. Thank you for joining us.
Good morning. Very glad to be here.
Yeah, we're happy you're here. We made it through the holidays, and we're getting a lot of questions about what do I do with my parenting plan. I've had some concerns or some issues uh, trying to see my kids throughout the holidays, and my ex-spouse or the parent wasn't really as cooperative. And so as we kind of wrap up the year and we're into this new year, what is your advice to clients who ran into some issues during the holidays with the other spouse or the other parent?
Well, first and foremost, the holidays are one of the more emotional times of the year. It's a reminder of both what you don't have anymore, as well as a reminder of what you want to have, that time with your kids, those memories, building Christmas or New Year's celebrations with them. And so in designing, your trajectory forward, what you really need to make sure is that you're documenting those issues so that after the holidays, when you're coming in and sitting down with your attorney, you can start going through, here are the issues that I've had. Here are some of the concerns that I've had, those aggressive or antagonistic text messages, if things begin to sort of go downhill when you reach out about having additional time, or trying to figure out, on Christmas Day, who picks up where, and things just become more and more hostile. Those are the types of moments that you need to make sure you're able to identify those with your attorney, because that's some of the, those building blocks of your case going forward, some of the potential exhibits and evidence. And the second component is, remember that you are always under the microscope of the court. Even if there may not be formal litigation that's been filed yet, the court's still going to be considering how you react to your spouse, or to your ex-husband or your ex-wife. And so when things begin to become hostile, when they begin to escalate, the best thing for you to do, remove yourself from the situation, because the court's going to be looking for which one of those two parents is best able to reduce the tensions, to reduce that conflict. Because at the end of the day, it's about your kids, and it's about making sure that you and your spouse, your former spouse, can effectively co-parent towards that end. And so the last thing you want to do after the holidays is have a conversation with your attorney about, well, here are the issues we've had, but as a heads up, you're also going to see some issues from, my ex-spouse's attorney, because I didn't handle myself that well either.
And as we're looking at the parenting plans, and parents have went through some of the issues that you were just currently describing, when is the best time to revisit a parenting plan?
Well, there's not a great answer for this, except to say that the best time is to start having a conversation with your attorney when you begin to notice some of those issues with the parenting plan that you're operating under. And those could be minor, inconveniences, like the drop off and exchange points are too distant or something, or it could be something much broader, like you have the beginning of Christmas holiday, and that just doesn't work out for your family. You're unable to logistically make it work. It's best to start having that conversation with your attorney, as soon as possible, so they can start advising you about how we can alter the parenting plan, coming up with, creative solutions with the opposing counsel, so that we can come up with a good plan going forward. But that conversation begins with, hey, I had some issues over holidays. Here are those issues. What can we do? It's always better to address them here in January than it is 11 months down the road in November, right before the next Christmas holiday.
Right. And, we've had guests on here previously when we were talking about the holidays and how important and imperative it is, to your point, to really just try to stay ahead of it as early as possible. And in your experience in South Carolina, where you currently practice, how hard is it to get into the courts as you reach that November timeframe?
Almost impossible. At the end of the day, the amount of time that the court has available to it around the holidays is extremely limited. And your what seems like an emergency because it's the end of November and we don't have a plan for Christmas is, in the grand scheme of things, not an emergency for the South Carolina Judicial Branch, because there are other families who have, allegations of physical abuse involved, or the Department of Social Services, they'll have emergency hearings that, have to be heard within 72 hours. And those are going to take precedent. And so it's always wisest to make sure that, back in September, August, you're putting the plan into play so that you have the hearing date before the court's time becomes so rare that you're not going to even have an opportunity to get in front of a judge before Christmas Day, really.
How important is it to document any concern or issues that someone has with the parenting plan?
It's incredibly important to document, not only because documentation is, most of the evidence and the exhibits that we can provide to the court, um, but life comes at you fast, and it's never going to slow down. Um, and what I find is that most people, the individual moments of, that give rise to these issues in the parenting plans, those can tend to be forgotten in the chaos of life. And so it's important to, even if it's a journal, an app on your phone, Google document, something to keep a running kind of list of when those issues come up, so that when you're sitting down with your attorney, you can start going through and saying, okay, look, well, on, December 17th, this happened. This was my response to it. This is, what her response to it was. Because you won't remember all of those by the time the holidays are over, by the time you get through New Year's and you're getting back into the swing of work. And now there's school issues to be involved with as well. You have new teachers, and now you're supposed to remember exactly what happened a month and a half ago. So that's why I always say it's important to keep a running kind of tally of that, whatever works best for you. But it's also incredibly important to make sure that whatever document you use is safe and secure, and only you and your lawyer will be able to access it.
When you're talking about documenting, is there a preferred method, whether it's via some court approved app? Is it just literally writing it down? Or is it something within your phone? All the above? In your experience, what's the best way to document any issues or concerns?
So my general approach is to say what works best for you.
Mhm.
Every person's different. I have some clients who are incredibly digital, and some clients who, are very old school. They keep that paper diary by their bedside, and that's the best way that they operate. Um, but I also have some who they need that sort of something just on their phone. They can pull it out when they get a text message, and they can save it in there. Others, though, in South Carolina, we use a program quite often called Our Family Wizard, which is a communication platform for parents, especially parents involved in litigation. And that allows you to keep, record of some notes and whatnot throughout the course of a case. But I would also recommend that, you make sure wherever you're taking those notes, it's in your control and custody, so that if something happens to a service, you won't lose access to all of that material that you've built up over the years.
Yeah, that's so important too, because we want you to be able to, however you're taking the notes or document everything, to do it almost as contemporaneous as possible. So you're it's fresh in your mind, top of mind, but then also, at least in my experience in litigating, when we're trying to enter it into evidence, that you want to be able to testify that you wrote it down contemporaneous, and that's an exact replica or how you remember it happening. Because to your point earlier, the longer that you go trying to write something down, you may not fully remember the whole picture, and it could potentially affect a ruling in the case. It may not be as big of an issue as it was because you didn't really fully document it, or maybe the court takes the opinion, well, if it was that important, why didn't you write it down right away? Why did you write it down a week or two later or months later, now that we're in litigation?
Well, and that's exactly it. By the time you have time to go meet with your lawyer, and you and your lawyer decide, okay, we do need to go ahead and file a motion, have a hearing in front of the court. It takes time to get that motion drafted, filed with the court, and you're still looking at, another 30 days before the court hearing. And now since since that heated argument with your ex-spouse, it may be 60, 75, 80 days out. And that's a long time, that you may not have remembered all of those details.
Right. Absolutely. Same with communication, because it's always so important, especially in litigation. When you're communicating with the your ex spouse or the parent of your child or your children, what 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 tone do you recommend clients using? Because I've been in situations litigating to where it's easy to debate the other side because they know what pushes their buttons, and I'm always advising clients, regardless of how you communicate, whether it's email or text, pretend that the court's copied on that same type of communication.
Yep. The earlier we had mentioned, it's always important to remember you're under the court's microscope, and that's even more so true when dealing with communication these days, because so much is by text. And by text, the second you hit send, it is not going to change. Whether you get a copy from, that your spouse's lawyer of the copy of your text message, or you subpoena it from the cell phone provider, the court's going to hear about what you said in that text message. And
Mhm.
so, the kind of three bits of advice I give is: one, at when you're sending a response, always keep in mind that the court's going to read it, your grandma's going to read it, and if it can't be read out at church on Sunday morning, you shouldn't send it. Two, once you type the message, don't hit send. Step back, give it a couple of minutes, come back to the text message and ask yourself, is this still going to achieve what I want it to? And if the answer is yes, hit send. And the third is, always, always, always remember that your lawyer is there to assist you. And so there are going to be times where, you may want to reach out to your lawyer and say, hey, would you mind just going through, giving a once over on this message? Because I think this message in particular, or this issue in particular, is important enough that I kind of need your eyes behind me. And that's one of the really good things about having a lawyer that you trust and have a good rapport with, is making sure that you can kind of identify when those moments are that you need a little bit of that extra, those extra eyes behind you, just to make sure you're sticking on the straight and narrow.
We've received comments from our prior podcasts and questions, and in some consults, that the holidays are over and the visitation or the holiday schedule didn't go according to plan, or I really didn't like how we arranged it and I want to change it for the upcoming year. How feasible and what concerns or issues do you see potential clients having when they have, we'll say, buyer's remorse? And then the second part that would be, if it's not buyer's remorse, it just didn't work out, and they want something that's a little bit more tenable and feasible.
Well, you kind of, it's a very difficult question, because it depends on the specific circumstances of that case. Are we dealing with individuals where litigation is ongoing, and so there's already a case, and this is something where we can wait to trial or mediation to rejigger a bit of the parenting plan? That's a lot easier when you're in litigation. But let's say you've been divorced, the parenting plan is part of that divorce decree. Then you're going to be looking at having to bring a modification action, and that changes what the court is going to be looking at, what the court's going to require from you, because you won't just have to show that the parenting plan hasn't been working out, but that the parenting plan is actually no longer in the best interests of the minor child. And that's a much more difficult threshold to reach than just, we had logistical issues, or we had these issues with how visitation went over the
Mhm.
holidays. And again, I know I keep saying document, 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 but it's what it comes down to. After the holidays, you need to have a conversation with your lawyer and say, hey, here are the issues that I've had. So your lawyer can then say, okay, well, this is something we can address with a letter to your ex-wife's lawyer, or this is something that we really need to look at addressing in mediation, or this is something that we need to look at potentially filing a modification action for. Here's what I want you as the client to start looking out for so we can build that case.
Mm-hmm.
Maybe not immediately in January, but February, March, April, maybe you'll have enough of those building blocks that you can go ahead and file that modification action. So again, it's the lawyer's answer. It depends, but that's what it comes down to in life. It's just like in parenting. It always depends.
In your experience, and you've raised a lot of points that we'll touch on in another episode, but just kind of sticking with that since the holidays have ended, just because things didn't work out the way that the client wanted them to, does that mean that they're essentially just stuck with that schedule, or can they try to work it out between the parties? And if not, is that something the court takes into consideration when you're looking at best interests of the children?
So at the end of the day, what the court wants to see are two adults who are working together for the best interests of their kids. And that's always a healthy starting point as a parent when you're dealing with, a parenting plan or holiday schedules, anything like that. There's nothing to keep you unless there's a no contact order or something, in which case this conversation entirely changes. But there's nothing to keep you from reaching out to your divorced spouse, to the other parent, and saying, hey, here's a couple of the issues that we've had, and here's my suggestion about how we can resolve those. That's always going to be step one. It's going to be the starting space. And the court's going to want to know that you're the one who attempts to negotiate in good faith, in a reasonable fashion. And so, if you offer a potential solution that says, hey, here's what I think we should do instead, that's a really good part for the court to look at and say, this is a parent who understands what the issues are, who understands how to come up with a solution, and is trying to work towards that. And if you still get rebuffed from the other side, again, going back to what we said earlier, go talk to your lawyer.
And that's good advice, because lawyers will know, especially depending upon the court that you're in, the potential attorney on the other side, the judge. There's a lot of factors that just speaking with your attorney can help, at least for what you were saying earlier, guide you along the right path to try to get to the end result you want. It may not be today, it may not be tomorrow, it may not even be in the next couple of months. But to your point as well, which I think is well taken, that you have to build your case if that's where it's reaching, because courts just don't want you jumping in right away because you're taking up docket time. It may not rise to a level to where the court thinks it's an urgent situation. And then you're potentially looking at sanctions and all kinds of different things that you really don't want to be a part of, to where talking to your attorney, he or she will be able to guide you as what's in your best interest within, again, of course, to be, and if there's kids involved, the best interest of the children. William, I want to thank you for taking time to speak with us today about, as we got through the holidays, and hopefully everyone was able to spend some quality time with their kids. But at least what we need to look out for, and maybe best ways that if we need to amend something, that what we need to do. And so if you're going through any issues, or if you need your parenting plan to be reviewed, reach out to Melone Hatley. We are more than happy to at least take a look to guide you as far as what we think needs to be done now, or as William said, what we can do to put you on that path to get to your ultimate goal. This is Melone Hatley's podcast, and Now Pronounce You Divorce. Please don't forget to like and subscribe, and send us questions. We always like to try to answer those on future podcasts. Thank you.
Thank you so much, Dan.
Thank you for joining us this week on I Now Pronounce You Divorce. Please join us next week for part 2.